What's happening, folks? Just decided that I would make a short video in relation to parking tickets and things like that. There was a video that I made a while back. Basically what I did was I went to Edinburgh, parked on a Royal Mile, and essentially tried to deliberately get a ticket, which I was successful at doing. Besides that, I made a video at the time showing how to deal with it. I sent a letter just to wind them up, just to show that you didn't have to pay for it. Since then, I actually made a follow-up video, but it got removed off YouTube, and I've noticed that there's a lot of people making a lot of comments on it in regards to that, wondering what's actually went on with it, saying that you can't actually cancel council parking tickets, you can't beat them, these types of things. It's only private companies. So I thought I'd show you exactly what I did. So here's the video.
So, I'm just back for the court at Indicamp, and I've been parked here on the Royal Mile on a single yellow line, no in a parking space, and there's no signs about anywhere telling me not to park them in at any times, or whatever times. It's a single yellow line, it's not a parking bay, and I've been left this wee present. Well, that's where it'll be getting sent back to, no contract.
Here's the final draft.
This is it here. There's the ticket. There's one note. All in it. There you go, all in there. In the envelope, front of the name. Second class, couldn't care less. Right. See that? Oh, nearly fucked that up. There you go, bit fucked, but it's sealed. Right, so here I am, on the postbox. Here's a letter, and it goes.
With me now is Tim Carey, a solicitor specialising in traffic law. Tim, not many people have trackers in their cars.
No, that's right.
So, irrespective of whether the cameras are working or not, what view do you take on these penalty charges?
Well, frankly, I'm surprised at the volume of these penalty charges that are being issued. People don't have to deal with them. People don't have to answer them because they're not. It's not a criminal offence not to answer these. If you get something from the police, you have to answer it, but not from a parking company.
OK, but people are worried about being taken to court. What are their chances if they're taken to court?
It's up to the parking company to prove the driver, and they have to sue the driver, not the owner, not the registered keeper. They have to sue the driver, and they have to prove that the driver was in breach of some contractual term.
Will they do that?
Well, I don't know of any cases where they've done it. Okay. I would think it'd be incredibly difficult for them to mount a case before a county court.
And the other worry when debt collectors get involved, that people's credit rating is going to be marked down.
complete nonsense, complete
Okay.
nonsense. The only way you're going to have your credit rating damaged is if there's a county court judgment against you which is registered.
So you really... So, I mean, when people get this, it does actually look like an official penalty charge,
Oh, it looks-
doesn't it?
looks
The
very-
yellow and the...
Looks
yeah.
very impressive.
What should they do if they get one
Well,
of these?
if my mum got one,
Yeah.
I would tell my mum to take it
Yes.
and to make one of these with it.
Yeah.
And once she's made one of these with it, I would suggest she sees how good it is by doing that with it.
Perfect.
Basically what happened after that then was they sent a letter saying they didn't care pretty much, and that I was still to pay it, I was eligible under the Road Traffic Act, etc, etc. At that point I then sent them another letter saying that I hadn't told them that I had agreed to paying it. I then said, no, you're missing the point, this is a notice, you have no lawful authority over me, show me your claim. And I also sent a common law copyright notice in my name at that point and sent them a fine for putting the actual ticket on my car.
So, as you can see here, this is a letter that I received for them, and nobody took any liability on it. It was signed by an unreadable squiggle, and that's pretty much what I said to them as well. They then went on to say that the only 6 acceptable reasons under the Road Traffic Act would have been that I either wasn't the owner, registered keeper, etc. That didn't actually occur in general. The vehicle was taken without my consent, aka stolen. The traffic order was invalid. You know, just all this bullshit, really, under their rules. But my main point that I had made is, I didn't consent to them. I was not giving them any authority over me. So what I then did is I replied with this. This is my reply here. I, a man by the name of Dylan, still do not understand your intentions towards me. You appear to have sent a letter addressed to a Mr. Dylan blah blah, which has been opened by mistake due to a postal redirection sticker on the envelope covering the details. I can only assume this letter is supposed to be to me though, as the letter appears to reference my previous correspondence with you. I am not Mr. Dylan blah blah. I am Dylan of the family blah blah, and I bear no titles. On the grounds that it appears to be to Dylan of the family blah, known as Dylan for the clan, who you have attempted to contact, I shall however in good faith respond. Please note, Mr. Dylan blah is a legal fiction who cannot open mail, write letters, answer phones or speak. Also please note, I am informing you in good faith now that you appear to have misused and infringed on my name. On this occasion, I will dismiss this infringement, as it appears to have been an honest mistake. However, I must warn you that the name Dylan blah blah and all derivatives are copyright under common law, and any further use without my permission will incur a charge of £1 million per use. I would like to clear this up so you don't cause any further infringements. You have the permission to refer to me as Dylan of the family blah or Dylan for the clan, and that is it. I've included a common law copyright notice in this envelope along with this notice. In your letter, you say that you have considered my explanation, however you are unable to cancel the ticket due to certain circumstances. I must point out that I did not send you an explanation, an appeal or a letter. I sent you a notice, telling you that you have no lawful claim and that I have no obligation to deal with you as we have no contract. In that notice, and then I dated it, saying what date it was, I asked for verification of any obligation there may have been by requesting the following: a wet signature contract, a wet signature bill, a copy of any previous written permission that may have been given to you by me that allows you to put something on my property, and proof of your claim of authority over me that would give you jurisdiction over me and my property. As far as I can see, you have failed to provide any verification of your claim. You then continued to say the property was parked on a single yellow line. May I point out that there was no sign stating that no one could park there during certain hours. You also say that a driver did not return, and I'm confused by this, as there was no driver at all that day. At no point was anyone using my property to operate in any commerce or for any financial gain. So on that basis alone, you have wrongly assumed and accused the user of my property of something that they have not done. I would also like to further point out that the 1991 Road Traffic Act does not apply to human beings. Acts and statutes only apply to persons, legal fictions. So if this was supposed to be a claim of authority over me, I must tell you that it is invalid and void, as no travellers using my property are legal fictions or persons of any kind. The Road Traffic Act clearly states it only applies to drivers and persons. In the previous notice, I in good faith offered remedy to this dispute by asking you to verify your claim. In view of the above, you have failed to provide me with any verification of any obligation any user of my property may have had with you. I would also like to point out the relevant legislation that you appear to have broken, the Bill of Rights Act 1688, and then I've quoted the Act, basically. So in view of the above, I am not satisfied with all this misconduct in the public office and gross negligence. This parking ticket has not just been incorrectly issued, but has been illegally and unlawfully issued, and through such action, the fine is now void, and any debt there may have been is now null. Also in view of the above, a bill for the removal fee has been issued as stated in the last letter dated, the date that I sent it, and is enclosed in the envelope along with this notice. Please pay the bill within 30 days of the date on this letter. Also, who are you? Who is making this claim? There is no human being called Parking Services, so I would like to know exactly who is making this unlawful and illegal claim. Is it T. Rosser as stated in the letter you have sent? Is T. Rosser the entity known as For Parking Services Manager who has signed the letter you have sent? I need verification of who is making this claim, as it appears to be fraud. Please note, all further correspondence between us will be on a fee schedule, as this has taken up my valuable and limited time on this earth. The fee schedule is as follows: £100 per letter received and £200 per reply. As I have said above, I in good faith offered remedy to this dispute by asking you to verify your claim. In view of the above, you have failed to provide me with any verification of any obligation any users of my property may have had with you. I hereby now give you 10 days to reply to this notice from the date of this letter with a notice signed under full commercial liability and penalties of perjury, assuring and promising me that all of the replies and details are true and without deception, fraud or mischief. Your said failure to provide the aforementioned documentation within 10 days from the date of this letter to validate this claim will constitute your agreement to the following terms. So what I did there is I basically made a tacit agreement with them, so that they had to reply with what I've asked for to prove their claim or they're in the wrong. So what I've actually said that they agree with, if they can't give me what I've asked for, is that the claim did not exist in the first place. Any damages I suffer, you will be held culpable. That any negative remarks made to a credit reference agency will be removed. You agree to pay all fee schedules. You agree to pay the removal fee. You will no longer pursue this matter any further. And that was it. Namaste, Dylan for the clan, authorised agent and representative of Dylan, or Mr. Dylan, blah. No assured value, no liability, errors and omissions accepted, all rights reserved. End of.
Afterwards, they then sent me a letter saying that they had put it on hold until they'd considered what I'd said. After that, it took about 4 weeks or something, 5 weeks maybe even a wee bit longer, and they sent me another letter. And then another letter came in, and because I'd sent them a common law copyright notice in my name, and the legal name isn't me. So essentially at that point, it was return to sender. Addresse unknown, return to sender. And that's all I did. And since then, I've never heard a thing back. I've never had any issues. I've no problems with my car. I've never had any bailiffs anywhere. I've never had anything. Absolutely nothing, because they had no claim over me. But that's basically it.